General, just a few questions following up on the major questions discussions you've had. You say that we shouldn't be so concerned in the area of foreign affairs because of the president's inherent powers. That's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the president the power to regulate commerce with foreign nations as he sees fit? To lay and collect duties as he sees fit?
We don't assert that here. That would be a much harder case now in 1790.
Isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying we shouldn't be concerned with. Yeah, I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation off the books, more or less. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did,
why not?
Well, because we're dealing with a statute, again, that has a whole series
I'm not
of
asking about the statute.
limitations.
General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions and non-delegation, what bite it would have in that case.
Yes. I would say by then you would move from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale abdication of.
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential. Okay. Limited is what, and again, the phrase that Justice Jackson uses, it just does not apply, at least.
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think we would, as our frontline position, assert the stronger position, but if the court doesn't accept it, then if there is a highly deferential.
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would be.
Well, you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now I think tell me if I'm wrong. You backed off that position.
Maybe that's fair to say.
Okay, all right.
That would be, I think, an abdication. That would really be an abdication, not a delegation.
I'm delighted to hear that, you know. Okay. All right, and then I wanted to return to something Justice Sotomayor asked under this statute, okay? So now we're in the statute. It's a major question, though. Could the president impose a 50% tariff on gas-powered cars and auto parts to deal with the unusual and extraordinary threat from abroad of climate change?
It's very likely that could be done. Very likely.
I think that has to be the logic of your view.
Yeah, in other words, obviously this administration would say that's a hoax, it's not a real crisis, but.
I'm sure you would.
Yes, but that would be a question for Congress under our interpretation, not for the courts.
All right. And then on this inherent authority idea, I understand the president's inherent authority in wartime, and a lot of your examples of regulating commerce, and maybe your best one, Hamilton, during the Civil War, they occurred during wartime when the president's commander-in-chief power is clearly in play. Does the president have inherent authority over tariffs in peacetime?
No, we do not contend that.
Okay.
And in fact, I'd cite, if I may, I'd point the court to two cases. They're Loving against United States and then Masery that's cited in Loving. Those are situations, for example, Loving against United States, The president had broad Article II inherent authority. There was the commander-in-chief power. But this court held he does not have inherent authority to do the power that was delegated to him, right, which is the power to, identify aggravators that make you eligible for the death penalty in court-martial trials. And yet this court said, well, we're not going to see a delegation problem here, even though it's really a wholesale delegation, which would otherwise be legislative authority. It would be kind of like a small version of what you're hypothetical. It would be an abdication. But because you're in a foreign affairs context or their commander-in-chief military context, where the president has his own delegation of authority, he doesn't have the power to do this. But because of his background inherent authority, the court said, this is a situation where we're not going to see a delegation problem when there clearly would have been a delegation problem in the domestic context. And those cases, I think, are powerful here.
General, if I can cut through those words, I think you're saying that no, the president doesn't have inherent authority over tariffs in peacetime.
Absolutely. That is, we do not assert that. We say that Congress can delegate that to him, and when Congress does so, as it does when it uses the phrase regulate importation.
I follow all of that.
I agree.
Okay. You emphasize that Congress can always take back its powers. You mentioned that a couple of times. But don't we have a serious retrieval problem here? Because once Congress delegates by a bare majority, and the president signs it, and of course every president will sign a law that gives him more authority, Congress can't take that back without a supermajority. And even that, it's going to be veto-proof. What president's ever going to give that power back? Pretty rare president. So how should that inform our view of delegations and major questions?
I would look at the balance that Congress struck, because what Congress did initially, it had a two-house legislative veto.
And we struck that down.
Yeah. And then Congress went back to the statute and amended it. Yeah. It took out the legislative veto and left in the joint resolution, but still left the president with all those powers.
That's what Congress did?
Yes.
Fair enough. As a practical matter, in the real world, it can never get that power back.
I disagree, because in January 2023, Congress voted to terminate one of the biggest IEPA emergencies ever, the COVID emergency, and the president went along with that. So what the statute reflects is there's going to be the ability for a sort of political consensus against a declared emergency.
Well, what happens when the president simply vetoes legislation to try to take these powers back?
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, so Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight
with the president's assent.
Is meaningful.
With the president's assent, in fact,
once he lost it by a veto-proof majority in the Senate, I think the position moved. And I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority to get it back. Yeah. Okay. One other question. Do you think tariffs are always foreign affairs?
I do think they would. I can't think of a situation where they're not foreign facing. If you're talking about tariffs on imports, I mean, maybe there are other tariff contexts that I'm not aware of, but yes, they typically would involve a foreign affairs thing. However, in Gibbons against Ogden, if they are revenue-raising tariffs, they would not raise the same sort of like foreign affairs issues as regulatory tariffs, which are imposed not for the purpose of raising revenue, but to induce foreign powers to change their behaviors.
So revenue-raising tariffs are not foreign affairs, but regulatory tariffs are.
I don't think a revenue-raising tariff would be foreign affairs to the same degree, at least. I think it has a foreign application, obviously, but I don't think it would raise the same issues.
Okay. Thank you, General.
Justice Kavanaugh?